All right, guys, I want to welcome everybody to our monthly episode of Work Comp Today. This is when Dave and I and a guest get to nerd out on work comp matters. Hey, Dave, how's your September 22nd going for you today?
Couldn't be any better. Thanks. Yours?
It's those type of responses that I so look forward to each month from you. But thankfully, we have a real personality with us. We have Stephanie Tucker, our buddy out of Colorado with the Babcock Law Firm. Stephanie, thank you for joining us. We want to wish you the very best of luck over the next 45 minutes to an hour hanging with us. How are you?
I am doing very well. I'm so happy to be here with you guys.
we can tell. We really, it's overwhelming. We know. Stephanie, before we hop into all these articles that impact employers, employees, and independent contractors, we usually bring on a friend, a colleague, someone from somewhere in the country who does similar type of work that we do in Alabama. So share about your practice and the Babcock Law Firm in Colorado and all the good things that you guys do.
Yeah, so I work for the Babcock Law Firm. I've been with the firm for 10 years now. In fact, just had my firm anniversary earlier this month. And we're a small, we like to call it a boutique law firm. We have 3 attorneys right now, and then a small handful of staff. And we focus primarily on workers' compensation here in Denver and the greater Colorado area. And we do a handful of personal injury cases as well, but we are certainly most well known for our comp practice.
And Dave, share how we know Stephanie and Mac and their firm.
Yes, so we met through the Workers' Injury Law Advocacy Group, a national organization made up of work comp claimants lawyers from around the country. And WILG's made up of some of the best and brightest work comp lawyers from around the country. And so we've gotten to know Mac and Stephanie through that organization. Glad to call them our friends.
We certainly are, and somehow they've allowed the Nomberg law firm lawyers to be members of that of the national organization. And we're going to see you guys live next week in person. We're really looking forward to the annual event. It's always a good time to share fellowship and break bread with our friends from around the country. Well, we have come to the time that we do each month. It's Work Comp for Nerds is what David calls it. We're going to we've got 5 or 6 articles to go over today, and Stephanie and David hopefully are as prepared as I am to go over these. But what it is, we try to take timely articles that impact our practices, that maybe they're state specific to Alabama, maybe they're state specific to Colorado, or maybe it can just be used universally regardless of what state that you're in. So guys, we're going to jump into the first article, which really is, I guess, a national one, but I suspect Colorado and other similar states probably deal with this much more so than we do in good old South in Alabama. Growing pains. Cannabis businesses are thriving, but these workers' comp hurdles remain. Stephanie, we brought this article first for a reason. We know that Colorado is one of the leading states when it deals with cannabis, and this, you have much more experience than Dave and I do in our state. So did you get a chance to review this? Did anything stick out that really would impact your practice or for injured workers in Colorado on this topic?
Yeah, well, so first of all, I did have to laugh when I saw that this was the first article that you wanted to discuss, because the Colorado attorneys are always asked to talk about pot. I can't tell you how many continued learning education talks I've given on the topic. So I've had to research it quite a bit myself. This was a great article though, and actually, so interesting with respect specifically to the workers' compensation system. The thing that I found most intriguing about the is that it talks about the difficulty that grow dispensaries and grow operations can have in finding appropriate workers' compensation coverage. It actually spurred me to do a little bit of research on my own. Actually, I even let one of my paralegals help me with that. I think she thought it was a very fun afternoon project rather than her normal drafting of pleadings. But to look into what some of our Colorado dispensaries and grow operations to see if they are insured. So we just did a very small little sampling. We found 6 different Colorado marijuana companies, and out of those 6, 3 are uninsured, it looks like, and I'm guessing maybe because of some of these issues highlighted in the article. The other 3 that are insured through the largest and quasi-state entity insurer in Colorado called Pinnacle Assurance. Interestingly, though, my paralegal Elizabeth indicated that all of those that are insured by Pinnacle are insured through another parent company. I'm guessing to try and get around some of the laws and issues that are otherwise implicated, given the fact that marijuana is, of course, still illegal on the federal level. So,
David, that's the type of guest we should have every month. Goes beyond the articles and does her own research. Top notch right there.
Shout out to Elizabeth for helping.
yes, I'll have to tell her that we give her a shout out.
And Dave, how much extra research did you do for our articles this week?
I'm here.
Thank you for not putting the cardboard cutout of Tua Tagovailoa this month. And we actually have the real Dave. Dave, does this have any impact in the state of Alabama right now?
Not terribly. I did want to share some stats from this article, though, just because I think they're interesting. Cannabis is now legal for recreational use in 1/3 of the US states and for medical use in 20 more states. So now you've got more than half of the states, almost 2/3 of the states, where recreational and or medical cannabis use is legal, but of course it is still illegal under federal law. And I think that's what complicates this work comp situation so much, because so many of these companies they're dealing in cash essentially. They can't bank their money, as I understand it. Is that your understanding, Stephanie, that these companies that sell, they can't put their money in a bank because it's illegal under federal law, and of course the banks have to be federally insured.
Correct. Yeah, here in Colorado, actually, it caused even more of a housing crisis because a lot of the marijuana operations were, since they couldn't put their money in banks, they were investing it into housing and causing even more of a shortage in the area. So yes, that's exactly my understanding, and it seems to be from this article one of the issues when it comes to obtaining insurance.
Well, I suspect, like a lot of the topics we talk about each month, this is not going away. This will be an ongoing conversation in the months and years ahead. Hopefully Alabama will one day wake up, who knows, but for now we'll leave it to the leading states like Colorado to pave the way for us. Guys, let's switch over to the second article. It's entitled, and I know David loves this article, this title, Chiropractic Care in Workers' Compensation. And before we dive in, I want to ask you both, is in your respective states, Colorado and Alabama, is chiropractic care accepted under work comp? Meaning, do some of the carriers in the cases that you handle, do they allow injured workers to be treated through chiropractic care? David, you go first.
In Alabama, no.
And do you know why, or that's just the way it's always been?
It's the way it's always been since I've practiced. Yeah, I don't ever recall a work comp carrier approving chiropractic treatment. Conversely, though, physical therapy we see a lot of physical therapy.
Stephanie, the way that you get to an authorized treating physician may be similar in Colorado, but in Alabama, in a claim that's accepted or when it's court ordered, the insurance company gets to dictate who you get to go to for the most part, because if they're going to pay, they have the input. And I don't ever remember seeing where any of my clients have initiated or had their initial care through chiropractic care. Usually it goes through a gatekeeper doctor. They assess the situation. They do the triage, if you will, and then it might get farmed out to specialists, and chiropractors are never on that list. What about you guys? What's your experience with chiropractic care in Colorado?
Yeah, so our process in terms of having a physician assigned to the case seems to be similar to yours. I always tell my clients that if I go buy a shirt tonight, I get to pick that shirt out, right? And so if an insurance company is going to pay for treatment, they get a say in where that treatment is done. Here in Colorado, though, we have our laws have changed several times, even just in the 10 years that I've been practicing. Right now, the insurance company and the employee share in the process of selecting a physician. So within a few days of reporting the injury, a week, the insurer is to provide the injured worker with a list of at least 4 different physicians that they can go see. They do need to be accredited physicians, MDs, DOs, who have gone through the appropriate training with the state of Colorado to manage workers' compensation claims. And so we never see chiropractors acting as those primary doctors on a claim. However, here in Colorado, through the chain of referral, we do see injured workers who are being referred to chiropractic centers. And especially this article talks a little bit about some of those integrated specialists, right, who have a chiropractor on hand, a physical therapist on hand, maybe an MD there in the same office. And we are seeing some of that. And in Colorado, chiropractic care can and is covered by the workers' compensation carriers. In fact, it's included in some of our treatment guidelines. We do run into issues pretty commonly with the duration of treatment, though. And again, this article comments on kind of the stigma regarding chiropractic care, that it just goes on forever. And so our treatment guidelines do limit for most folks the amount of chiropractic care that you can get. And we really put an emphasis in our system on trying to transition folks out of chiropractic and physical therapy to more of an at-home based exercise program.
Well, with the two of y'all being triathletes, I figured that article might have some resonance with you guys. But then we should have made this the athletes month with the two of y'all. But anyway, let's move on to the next article. And this one really, this is a tough one. Firefighters diagnosed with cancer struggle for help in a system that needs fixing. And in fact, this one comes out of the state of Colorado. Stephanie, by chance, do you have knowledge of this case or this situation before this was published recently?
Yes, absolutely. And firefighters and the issue of their contraction of cancer is a big topic in Colorado. It's something that we've had quite a bit of legislative changes in the last several years, including the presumption bill that's discussed in this article. And of course, that is a presumption that firefighters here in Colorado who've been at their job or doing firefighting work for at least 5 years, if they contract certain types of cancer, as indicated in this article, that they are presumed to have contracted that cancer on the job. Because of course, the process of determining where someone contracts cancer is very difficult, and it's a very difficult evidentiary issue. So we are very proud of our presumption law here in Colorado. And as I said, it's a pretty common topic when we're talking about legislation.
Well, Dave, I know I don't even have to ask you if we have any type of presumptions about this on this topic, but doesn't this resonate a little bit? I don't know if this is a proper analogy, but to me, it's very similar with COVID cases. How do you narrow down the source, the origin of someone being diagnosed with COVID? And Stephanie, of course, Alabama has no presumptions about anything to protect injured workers. But David, what would the state of Alabama, how would they deal with a first responder being diagnosed with cancer from a workers' comp standpoint?
Well, firefighters do have some laws specific to them, not specifically in the Workers' Compensation Act, but they do have some benefits for them. I love the idea behind this law and the spirit of this law and the presumption in favor of it being work-related. It sounds like, though, that it's been very difficult for those who are applying for the benefits to actually get approved.
Yeah.
So. But a great law.
Yeah, and they would have a much higher burden in the state of Alabama. Unfortunately, I don't know of any claims that have been brought forth in our state for this. Guys, if you're just joining us, if you're watching us on the replay, this is our monthly work comp today. Each month, Dave and I and a guest go over the articles and news and information that impact workers, employees, employers, and independent contractors. And our guest this month is our buddy, Colorado attorney, Stephanie Tucker, who is with the Babcock Law Firm. We're so glad that Stephanie's joining us. And we're just going to keep going through these articles. But before we get to the next article, I want to take a 2-minute sidebar, if you will, to talk about the annual WILD conference that's coming up. And 1,000 lawyers from all over the country and many other countries come in for an entire week or so. And we just get a lot of work done. Stephanie, what are you looking forward to besides hanging with Dave and me and the gang? What are you looking forward to at the conference this next week in Arizona?
Well, actually, obviously, the number one thing I'm looking forward to is seeing you and all of our other WILG friends who at this point feel more like family. And it's truly, the WILG conferences, and I think that we talk about this every year, but it's such an invigorating and kind of refreshing experience to go and tell war stories and brainstorm and just be around the folks who do the same thing that we do every day. Every single year after our WILG convention, I come home feeling kind of rested and excited to get back to work. This job can be difficult and can really kind of bring you down sometimes. And our WILG annual convention fights that and gets me excited to keep the good work up.
Stephanie, along those lines, and Dave, I bet you'll echo this. It is amazing that we may have, as you said, hurdles in our practice, but when we go and hear some of these speakers and we're around some of these practitioners from around the country, some of the smartest people you will ever be around, they just come up with, this is how we do it, or this is how I suggest you do it. And Dave, don't we come back and there's just so many things that, like Stephanie said, we can incorporate in one way or another into our practices.
Yeah, we're getting to spend time with the best and brightest work comp lawyers in the country, and you're going to learn from them. And I was just thinking back to 2016, I believe, is when I met Stephanie's partner, Mac, in Arizona. My wife and I were walking to one part of the conference, crossing over a golf course, and we stopped Mac and asked him to take some photos of us because it was a nice night, and that's where we met Mac. And then 2 years later, Mac and I helped put together the conference, the speakers for the Vegas conference. So we really got to spend some time together doing that. And here he is now, the outgoing president of the organization.
Yeah. Now in 2016, when he took those pictures, did he actually turn the camera around and take it of himself, or did he take it of the two of y'all?
I would imagine if I go back and look at my camera roll, there'll be some up close photos of Mac.
And Stephanie shaking her head. Yes, he did. In fact, I'm sure.
Probably not even to be funny. He's just technologically challenged.
And Mac, I hope you watch this at some point or another. All right, guys, let's dive into the next article. New Alabama, Georgia laws take effect today, indirectly effect and effect in the same sentence, insurance. And this actually is from July, but Dave, I brought it in for us to go over because it really is something new for the state of Alabama. What did you take from the Alabama side? We'll leave the Georgia side alone since we don't have a Georgia practitioner with us, but what did you take from the Alabama side?
Yeah. So I checked on SB 150, and it looks like this law passed March 31 of this year. And this law states that gig workers are to be considered independent contractors and not employees of marketplace app platforms such as Uber, Lyft, Handy, and others. So basically what it's saying is if you're a driver for Uber, Lyft, then you are an independent contractor by law. It is on the books that you're an independent contractor. You're not an employee. And so what that means is you as a driver don't have the benefit of workers' compensation unless you buy it for yourself, and you're going to not be considered an employee, so you will lose other benefits that employees receive from companies, 401k, sick and personal time, short-term, long-term disability, unless these are things that you pay for yourself, health insurance. What am I missing? Paying into Social Security, that or Medicare, right? The employer won't pay the portion of that. The employees on their own for that, or excuse me, the drivers on their own for that.
But you just mentioned something, and Stephanie, I want to see if you've had this experience. If you're a driver for one of these companies and you purchase auto insurance, we have found many times there's going to be a clause in there that says if you're driving for professional reasons, there's an exclusionary clause in most of those policies. Have you guys come across that? What's the purpose of having that insurance if you're intending for it to be for professional reasons?
Yeah, no, we have seen the exact same thing. And unfortunately, I think it's not very well advertised at the time of taking out that insurance. Unfortunately, a lot of these folks who are doing hard, difficult work, the Uber drivers and what have you, take those policies out with the best of intentions. And then only after some sort of, catastrophic injury or issue do they find out that they don't have the coverage that they thought they did.
Yeah.
So.
Yeah. This is David. Just as a reminder, we started this show 3 years ago in Santa Barbara, and Atlanta lawyer Ben Gerber was our first guest. And in the 36 odd months that we've done this show, I bet you 2/3 of the shows we've had articles dealing with some form or some area of the gig economy, whether it's Uber, whether it's you name it. And it's an ongoing, ever-present issue for folks who work in those industries. And like a lot of these other ones, and I notice I haven't said Amazon yet, those articles, these issues are not going to go away anytime soon. All right, guys, we are moving on to Oregon. Oregon OSHA adopts permanent COVID safety rule. And before we jump into there, I'll ask you, Stephanie, have you guys dealt with any permanent COVID safety rules in Colorado that have impacted your practice?
No, no, we haven't seen any COVID safety rules that have impacted our practice. With regard to COVID, the biggest issue that, as you actually mentioned earlier in this podcast, has been the issue of causation when we have folks who believe that they contracted COVID on the job. Mac, the owner of the firm, was actually very, very involved with some legislation that we tried to pass here in Colorado, establishing a presumption, much like the firefighter presumption. The bill was intended to indicate that folks particularly in fields like the healthcare industry, that if they contracted COVID, it was presumed to be a result of the job. Unfortunately, that was not successful here in Colorado. It was a big blow to Mac and to all of the attorneys across the state. So that's really been the biggest issue that we're seeing, is just simply the issue of establishing compensability and proving where the COVID was contracted, because of course, that is the nature of COVID. It is absolutely everywhere.
Yeah. Dave, I don't even have to ask you. We all know the answer if it impacts the state of Alabama.
No presumptions were passed by the Alabama legislature in favor of employees. Zero.
Frankly, in our state, the only thing that there could be a presumption of would be to benefit Alabama football. That would be the only issue that they would ever pass. Anyway, I'll move on, guys. We've got one more article for this month's discussion. And frankly, this is to me, this is as hot a topic outside the COVID issues as anything we have in our practice. And that's dealing with mental injuries. Defending psych comp claims, a trending topic. And this is, of course, nationwide. In Alabama, Dave, mental, do we have those types of claims that are successful? And explain what that means.
Yeah, no. So in order for work comp to pay for medical treatment related to a mental or psychological injury, there has to first be a physical injury sustained. So it has to be physical injury before you get a mental injury. If you go to your employer because you saw something like a coworker die in a catastrophic accident, or you're struggling at work and you have or PTSD or depression or something like that. If there's no physical injury, then work comp will deny that and not pay for any medical treatment.
Stephanie, we had just today, I dealt with a phone call, a now newly retired police officer in our state witnessed 2 murders right in front of him within 20 feet of where he was standing. PTSD was the diagnosis, and he had to retire based on that. Anyway, we're helping him with the Social Security disability claim. But the difficult conversation was explaining to him why there was no workers' compensation claim that he could pursue. Of course, he had done his research, and he's telling me this and this. What states are you? Well, of course, it's other states. What about in Colorado? Let's talk about psych or mental claims. Is there a mental, or is it mental physical? Share a little bit about that.
Yeah, we are lucky in Colorado in that an injured worker a worker can bring a pure mental, or as you're calling it, mental claim. It can be very difficult to establish, though. In our statute breaks it down into 2 different varieties. We have pure mental impairment claims that fall outside of the employee's usual experience, and then mental impairment claims that fall within their usual experience. So when the incident that caused the mental impairment falls outside of their usual experience, it has to be an incident that would evoke significant symptoms of distress for someone in similar circumstances. And the event, but luckily the event does not have to bring out an identical reaction in similarly situated employees. When the incident is within the worker's usual experience, there has to be a PTSD diagnosis. And then you have to prove that the employee was subject to another's attempt to cause serious bodily injury or death through force, or that they witnessed death or the immediate aftermath of a violent event. And in both of those types of claims, you do also have to prove that you would not have been subjected to the incident that you were subjected to, but for your employment.
Mm-hmm. And the article specifically mentions or differentiates between COVID claims where people are afraid to come back into the workplace versus those PTSD type conditions where, as you mentioned and I mentioned, where there was violence or there was some type of trauma that they experienced. But it's these articles that we choose each month. Hopefully are timely, hopefully are things that are still ongoing, but a lot of them unfortunately still require more and more discussion and follow-up. There's very few of these articles we ever get to where there's a definitive answer in the article, and then that's it. You just leave it alone. So that's why Amazon, that's why gig economy, that's why these things continue to show up in our show each month. Well, guys, that'll exhaust our articles for this month. And now what we typically do, Stephanie, is we analyze either some procedures or some laws that impact our guest's home state, Colorado, with those in Alabama. And again, this is where David and I just end up shaking our head, and we are envious of some of the things that are accomplished in our guest's home state. But here's the first thing for you guys to discuss a little bit. Stephanie, if an injured worker tests positive for a banned substance, whatever it may be, whether they're drinking or an illegal substance or narcotics, how does the work comp system in Colorado treat that positive test?
Yeah, so one of the first things I tell clients who ask that question, they'll often have questions about whether their job is in jeopardy as a result of that positive test. And it seems to be a misconception, at least here in Colorado, that if you filed a work comp claim, your employer can't fire you. Well, yes, they absolutely can. There's no special protection of your job just because you have an ongoing claim. And as you're asking, Bernard, Testing positive for an illegal or banned substance can affect an injured worker's entitlement to benefits. And that comes in three main ways here in Colorado. First of all, if the employee was intoxicated at the time, if the testing indicates that the employee was intoxicated at the time of the incident, there is a 50% penalty on monetary benefits. And those blood tests or otherwise positive drug and alcohol testing is present, there is an automatic presumption that the injury was caused because of the intoxication. As I already mentioned, the positive drug or alcohol testing could also result in the loss of someone's job. And that's another way that there could be an impact on workers' compensation benefits. In Colorado, if you are off of work following a work injury, you are normally entitled to wage loss benefits called temporary total disability. But if you have lost your job or are terminated for cause, then you are no longer entitled to that benefit. So again, I tell my clients, if you walk, if you have a work-related injury, and then afterwards you walk into your boss's office and punch them, you will probably be fired and you will not be entitled to wage loss benefits because you engaged in a volitional act that caused your loss of job and loss of wages that is unrelated to your work injury. And so the same question comes up when it comes to a positive drug or alcohol test. Many times employers then fire that worker and indicate that that was a termination for cause, especially here in Colorado, kind of tying this back into our discussion regarding marijuana. We see lots of issues where my client says, yeah, I smoke pot or I use edibles or whatever it may be. I always have. My employer knew that, never cared before because it's legal here in Colorado. Now I'm injured and suddenly they care. Suddenly I'm losing my job and being told I don't get wage loss benefits. And so there's often a question of fact, especially when it comes to marijuana. Was it really the employee's volitional act that led to the termination, or was it more so a vindictive action taken by the employer? The third way that positive drug tests or alcohol tests can impact Colorado workers is where a safety rule allegation is made. So our statute indicates that if an injury results from an employee's willful failure to follow a safety rule or use a safety device that is required by the employer, then monetary benefits are cut by 50%.
Wow. Dave, just because you test positive post-accident, does that automatically cut off all your benefits in Alabama?
It shouldn't, but a lot of times it does. The work comp carrier or the employer, the burden is on them to show that the impairment or the intoxication was the proximate cause of the injury. So usually a positive drug test will automatically result in a termination of compensation paid to the employee. And then the burden gets back on the employee to show that that the impairment was not the cause of the accident or the injury. Interesting, Stephanie, in Alabama, if the injured worker is found to be impaired or intoxicated, then you don't get any compensation benefits. It doesn't go to 50%, it goes to zero. Yeah. They still get medical treatment, regardless of what happens. They still get medical treatment, but their compensation goes to zero. No TTD and no PPD or any other compensation.
I had a case several years ago where my fellow was working on a construction site inside of a large warehouse. And at the time he was changing his shoes, he was in the designated spot for employees to do so when a large portion of ductwork fell out of the ceiling, landed on him, crushed his neck and his back. Well, he gets drug screened, it's positive, but he did nothing to contribute or cause his accident. He just happened to be positive with the screen, so he was able to get full benefits, not just medical care, but also any compensation that was due to him. But it takes a scenario like that a lot of times to be able to get those benefits. All right, guys. Now, we've already, I shouldn't have put this one in here. Mental, physical versus mental. We've already gone over that one. So you guys can cut a break there. All right, our last comparison between Alabama law and policies, procedures with Colorado's is closing of medicals versus a Medicare set-aside arrangement versus open medicals at the end of a case. And Dave, I want you to lead off. I want you to talk about first, let's talk about the difference when you're closing out your case. Do you have to close medicals? Are you forced to close medicals with part of your resolution of your case?
So the Alabama Work Comp Act provides medical treatment for the injured body part for life. It's a lifetime benefit. Now, in practicality, most work comp carriers or employers are going to want to close medical benefits as part of the settlement, but the injured worker is not required to. They may be offered only a settlement that closes their medical benefits, but if they don't like that, then they can take their case to trial and let a judge determine their degree of disability, and then the judge will leave medical benefits open under the Alabama Work Comp Act.
And that becomes, doesn't it, oftentimes a source of negotiation in a lot of these cases?
That's right. The work comp will pay, the employer will pay additional money to the injured worker to close their medical benefits.
And we'll come back to MSAs, Medicare set-aside arrangements, in a minute. But Stephanie, I want to go to you for the same thing. Open versus closed medicals. Is that an option in resolving your cases in Colorado?
Yeah, so in Colorado, I would say that our statute really doesn't consider or isn't designed to provide medical benefits to an injured party for life. Generally, the bulk of medical benefits available to an injured worker in our state are only available until the worker reaches what we call maximum medical improvement, or MMI, which means that they've reached a new baseline, or another way to think of it is that the providers indicate that they have provided all available medical remedies for the condition. At that point in time, for most Colorado workers, that ends their entitlement to medical benefits and medical care through the workers' compensation system. There is availability of what we call maintenance care following maximum medical improvement, but in Colorado, it's generally pretty minimal. It's really whatever the injured worker needs in order to keep their condition from deteriorating post MMI, and we usually see it for a number of months or maybe a year or so after MMI. I always tell my clients that they should not anticipate that medical care will be provided for life. It is really and only in the most catastrophic injuries, right? Paraplegic, quadriplegic kind of cases where we see medical care that goes on for a significant period of time. When I have a client who is choosing to settle their claim with the work comp carrier rather than simply let it come to a close administratively through the maximum medical improvement process, there's an option. You can settle with medical benefits open. Although most carriers are not interested or willing to do that, generally they want to close their books and know that they're no longer responsible and don't have to set aside any, reserves for that case. And so generally in those cases, if there is a significant need for ongoing treatment, or if the individual is Medicare eligible or covered by Medicare, we are looking at a Medicare set aside to provide them treatment post-settlement.
Sticking along what you just said, what about medicine? What if they're in pain management, Stephanie, of some sort? Is that treated differently than actual medical care? Or when you say medical care going forward or after the case, is that all wrapped up together as the same thing?
Again, it's pretty much wrapped up. In theory, medications and medicine can be provided following maximum medical improvement, but I always tell my clients to be prepared for that day because eventually the insurance company is going to move to cut off that treatment. Eventually, they say, this treatment is no longer related to your lifting injury. Oh. Now your back pain is just due to the fact that you've aged another 5 years, right? And the problem is that the insurance company really has an unlimited number of chances to try and cut off that care. If they go to a hearing and are unsuccessful in front of a judge the first time, they just wait a couple more years and they try it again until eventually they can be successful.
Dave, if you remember about 2 years ago, I concluded the closure of medical care for one of Dad's cases from when I was in high school. Stephanie, this was in the 1980s. This man resolved his case. And then fast forward to 2020 or 2019, the insurance company finally comes to him and says, all right, we want to end your medical care. And this case is 40 years old. It's incredible the amount of money this company spent. Guys, we're going to conclude sticking with this same open versus closed versus MSAs. I know that if we start talking about MSAs, we could take up the entire rest of the day. So we're going to limit it to really just one specific area. First of all, David, in 30 seconds or less, explain what an MSA is in general.
Oh boy.
In general.
MSA is a Medicare set aside. And what that means is if the injured worker is a Medicare beneficiary, they can't just close their medical care and shift the financial burden to the federal government. Federal government's interests have to be taken into account. Well, how do we do that? Well, a allocation report is put together, meaning a look at their past medicals and future medicals, and that information shared with the Centers for Medicaid and Medicaid Services, or CMS, and they will go thumbs up or thumbs down, and meaning that's enough money in the proposal or not enough money. And then you get their blessing, and then you can have a Medicare set aside and close medical benefits with work comp. And that money will go to pay for the injured workers' medical care on the injured body parts for the remainder of their life.
37 seconds. That was excellent. Stephanie, do you guys deal with MSAs?
We do, with some regularity. There are, as you guys are obviously also aware, there are times where if you are settling a workers' compensation case, you are obligated to set up a Medicare set aside. If the injured worker is a current Medicare beneficiary or is expected to become one in the near future. And so it's not on every case, but especially when we are looking at full and final settlements, I would say probably 20 to 30% of those cases require a Medicare set aside. And it's, of course, in those cases in the injured worker's best interest to have that protection as well.
And it really takes a lot of education on our part to the injured worker, our client, to explain how this checkbook operates. And one of the things, and I'm sure you guys do this as well, we never want our clients to be responsible for keeping up with that checkbook because of the requirements that are in place. So we always make sure that companies like Amitros, one of our partners, they handle the checkbook for the client, for the injured worker. But just that whole concept, I think we do as much education on that one area of probably equal to or more than we do the rest of the case leading up to that point. But anyway, we don't have to get too much further into that because, like Dave says, this would then become work comp for nerds. But guys, we have come to the conclusion right on time of this month's episode. Stephanie, we want to thank you for sharing some time with us today. 6 articles and a whole bunch of comparison of this Colorado laws and procedures with the good old state of Alabama. So thank you.
Thank you.
Dave, as I always do, I know you give us words of wisdom that keep us going to the next episode. What is it that you've conjured up for today's topic or episode?
I will leave our audience with this thought: be of service, help other people. And Stephanie, look forward to seeing you next week.
Same.
Guys, this will conclude this month's episode. Dave always with a good one right there. Next month, we'll be back in about 3 or 4 weeks for our October episode of Work Comp Today. We do appreciate anybody who watches, contributes, comments, etc., including our mother and any other mothers out there. You guys have a good, safe rest of your month, and we'll catch you in October. You guys be well. Bye-bye.